Reminder. There you go.
Okay. Sure. Okay. Okay, so we're going to go to the second slide, and we've had quite a hiatus between our first and our second. I mean, this one and the one before, but I'm not going to do any review because I want to get into this time. These that we're looking at, some of them are like one sentence and some of them are like this one where it is, and I didn't get it highlighted properly. How odd. It's just because I was in too much of a hurry. Anyway, this is Arizona Constitution, Article 2, Section 17, and it's eminent domain and just compensation for private property taken public use as judicial question. That's the only part that's showing, but the rest of it is there. So this one is one that's big and long. Some of them are only one sentence, and I was in too much of a hurry, obviously. So okay, so this says private property shall not be taken for private use, except for private ways of necessity, and for drains, flumes, or ditches, or on or across the lands of others for mining, agriculture, domestic or sanitary purposes. So right off the bat, oh, for heaven's sake, hold on one second. Let me just, all right, that's Jennifer. All right, so right off the bat, we know that eminent domain is a problem these days, that it's been used and misused in many different ways. So let's just look at what so it says, no private property shall be taken or damaged for public or private use without just compensation having first been made, paid into court for the owner, secured by bond as may be fixed by the court, or paid into the state treasury for the owner on such terms and conditions as the legislature may provide, and no right of way shall be appropriated to the use of any corporation other than municipal until full compensation thereof shall be first made in money or ascertained and paid into the court for the owner, irrespective of any benefit from any improvement proposed by such corporation, which compensation shall be ascertained by a jury, unless a jury be waived, as in other civil cases in courts of record, in the manner prescribed by law. Whenever an attempt is made to take private property for a use alleged to be public, the question whether the contemplated use be really public shall be a judicial question and determined as such without regard to any legislative assertion that the use is public. Okay, all that to say, they're not supposed to be taking people's private property unless it's for specific purposes. So what do we see happening in our world with eminent domain? Yes, Rima.
My, where am I? I've lost you. There we are. Okay. My property value has been dropped. My property has been taken for private use by AT&T. They're putting up a tower at the corner of my house, which has decreased the value of my house by at least 20% without my consent. So,
Yes. And they didn't even offer to pay you for it, did they?
No, they did offer to turn it on and kill me.
Yes, of course.
There is that.
Yes, there is that. And so that's one situation. Any others that we know about with eminent domain?
What the heck is? There's a fire department truck that just pulled up in front of my house.
Okay,
So it's like, whoa, what's going on? Okay. All right, he's backing up. I'm not gonna pay attention. Okay, yeah, I mean, it just freaked me out. I'm hearing this truck at this hour of the night in our subdivision while I'm at the dead end, you know?
right.
Deborah, can you explain to me eminent domain to make sure I understand that?
Okay, well, so what it's supposed to be is what it says in that first sentence, that private property shall not be taken for private use, which is what's happened with Rima,
Right?
okay? Except for private ways of necessity and for drains, flumes, or ditches. So what the idea is that occasionally there's going to be a need for property to be used for public purposes that, but the person owns this property. Okay, and so, but now we need it for public purposes. All right, and so here in Phoenix, on my side of town, on the west side of Phoenix, they're planning on in the future putting in an expressway that would have just run over a whole bunch of people's houses, and so they've purchased all that property because, and they did it under this eminent domain that it's needed for the public. And if somebody objected to it, well, then it went to court and they lost.
Mhm.
Okay, because it's, it's for public. And so they were theoretically paying a fair price for the property. But, in some cases, this property, because it's south of here and it was farmland. Okay, so these people have been on these farms for, a century or more. Some of them, well, they didn't want to give up their land. They didn't want to do it. But the court made them. Every single case they ruled against them.
But isn't that against constitutional language?
Yes.
Because I'm thinking of how in some of the other webinars, hearing David talk about this.
Yes. But so they've built some things in here into the Constitution, but what they've done is also pass statutes. And you see in this one that it has to depend on judges and juries. Okay, you see that in here. Well, so there was a case. So the one of the more recent ones that was huge was one here in the area where they wanted to build an expressway across an Indian reservation. Well, that's a problem because that's tribal land. Okay. However, and there was even a proposition about it in our elections, and people voted against it. They said, no, don't do that. So then they just took it to court, and the court decided, yes, we're going to, and they took the land.
But without a jury.
I don't know if there was a jury or not, but in the end, the Indians got paid, they got paid for the land that they took for the highway, but that wasn't the point. The Native Americans value land in a whole different way than we do. And this was their land. And it was just taken because they wanted to put a highway in there.
And there's no recourse for them.
Nope. Now, in the end, they made, lemonade out of, problems because they put a casino in right along the road that was now put on their land. And so they're making money, you know. But that's not the point.
Mhm.
Yeah. And
So
then-
back to, okay, go ahead.
no, go ahead.
I was gonna say back to Rima's property. So Rima property has this 5G thing going up, right, Rima?
Yep. Yep.
Okay, so, and did you prevent them from turning it on?
Well, that's the answer is I don't know. They haven't turned it on. It's got 4 powerful antennae, and they haven't turned it on. But usually they build these things in triads, and this is the only one. I don't know why my hand's up. This is the only one that has been built, which makes me think it's actually a weapon rather than a communication
Oh.
device. And so far, they have not turned it on.
So,
Would you
There
know
it is.
that
It's
it's
just the very presence of it has diminished the value of my property.
okay, and it's on your property?
yeah.
No, is it on my property?
Well-
It's at the corner,
Oh, no,
my
so
property.
it's at the easement.
right of
then.
way.
It's in the right of way.
Easement, okay.
Right. Right.
So would you know if the 5G was turned on, Rima?
The eucalyptus tree that, not eucalyptus, the whatever the hell it's called. I forget the name of the tree. That is
Mesquite.
mesquite. That's right there would start dying.
Oh,
And that hasn't happened. And I'm pretty sure that with the proximity and power ratio that they're going to turn on, I'm pretty sure I would feel something, and the
Okay.
dogs would.
Right.
okay.
So anyway, interesting.
Mm.
This and I, something about eminent domain is in almost all the constitutions. What they've done is use workarounds. So they haven't changed the Constitution. They've changed statutes, and they've changed the justice system, we know, to work to their benefit.
Mm.
So it's in the Constitution, but it's not being used that way. Okay. All right, so let's go on to the next slide. Here I did it right. It's so exciting. So
Doesn't take much to make you happy.
I know it doesn't. So
Me too.
Arizona Constitution, Article 2, Section 18, imprisonment for debt. There shall be no imprisonment for debt except in cases of fraud. That's fairly clear cut. Okay. All right. So now,
Now-
go ahead, Rima.
Do we assume that this means solely financial fraud? Because there are many kinds of fraud. So for instance, if you were to show that a vaccine manufacturer in the state of Arizona or selling product in the state of Arizona had done so making false claims, safe and effective, when they knew that it was neither safe nor effective, would they not then be subject to this this
Problem
clause?
with the problem, and maybe it's possible. The problem that David has pounded into our head with fraud is that you have to have witnessed the actual fraud
You
happening.
yourself.
Yes. Yes.
You have to find the person who committed the fraud.
You have to witness it.
Okay. Whoever brings the claim of fraud, right? Is that what you mean?
Right.
Okay.
Right. Otherwise, it's just going to get thrown out.
No,
Yeah,
wait,
it
wait, wait.
probably-
If you pass a bad check to me in the
Yes.
mail,
Yes.
you mail me a bad check for
Right.
$10 million. And I
Right.
am stupid enough to cash it because there's no law against stupid. Or take it to the bank. And you knew that check wouldn't clear.
Right.
I didn't see you write the check. I didn't see you mail it. I didn't see you do anything, but it's got your signature on it. And that's not fraud.
I don't know the answer to that. I don't know. it possibly is because you have the check. You know, possibly. I suppose if it was my check that I sent to you, I might claim somebody else wrote it rather than me. You know, we might be able to make sure that we got a signature verification to know that it was, but hold on just a second.
Your
Hi,
bank calling about the check.
Jennifer, I'm in a class right now, hon.
Okay,
The check is bouncing. Lima.
It's like 4 in the morning here, but I am like sick to my stomach. Can you just tell me real quick where our name?
I actually received a check from what turned out to be a Nigerian scam for more than $3 million. And instead of, and it looked like a good check. Instead of
good.
depositing it, I took it to the bank and I said, this is fraudulent and I don't want to deposit it. And I got a call from the FBI asking me why I was engaging in Nigerian fraud. And I said, could we start again, please?
Mhm.
I said, I didn't want to deposit it, not I did want to deposit it.
Oh,
Right.
wow, that's really strange. Just out of the clear blue, you mean?
Yeah, in a FedEx envelope, I
Oh,
opened it up and it, you know how there's a micro perf strip
sure.
between the, okay, so this was just the bottom half and it was made out to me and it was from a law firm in Manhattan. I got it on Friday after close of business. So I called them Monday morning and I said, your firm issued this check to me in $3,564,915 kind of like amount. And they said, that's odd. That's the exact amount of our monthly rent. This was a big law firm in the center of Manhattan. That's the
Oh,
exact
wow.
amount. I said, well, somebody in your bookkeeping department is not playing quite clean. And they said, well, never mind. So I took it to the bank and I said, this is a check I'm not depositing. You might want to look into this. And then I called the terrorism part of the FBI. And I said, you know, somebody's doing some financial thing. This originated in Nigeria and they've stolen the money and you might want to look into this. And nobody cared.
No, of course not. Okay, so we'll go on to the next one. Rosemary, Jennifer is freaking out
Okay.
because of the jot form for them that when she thinks she signed one of them and she's asking after we're done, I told her it probably couldn't happen tonight, that could you check and see if she signed one? Okay.
Okay.
I'll tell you why later. All right, so
Okay.
now we're on to Article 2, Section 19. Rima, you want to read that one?
Sure. Arizona Constitution 19, bribery or illegal rebate. Why did you ask me to read this? What do you know that I don't know about?
I don't know.
Bribery or illegal rebating. Witnesses, self-incrimination, no defense. Any person having knowledge or possession of facts that tend to establish the guilt of any other person or corporation charged with bribery or illegal rebating shall not be excused from giving testimony or producing evidence when legally called upon to do so on the ground that it may tend to incriminate him under the laws of the state. But no person shall be prosecuted or subject to any penalty or forfeiture for or on account of any transaction, matter, or thing concerning which he may so testify or produce evidence.
So if you're called as a witness, you kind of have to go if you're subpoenaed, but you're not going to be held, you're not going to get prosecuted yourself, is what I think it's saying. That sound right?
Sounds like to me.
Yeah. So it's pretty clear cut. If you're hanging out with the bad guys, you may end up being a witness. Um, so there's that.
Hmm.
Okay, let's go on to the next screen. All right, so, okay,
Mhm.
This is 20.
okay, hold on. Okay, yes. All right, so Sandy, read those two, please.
Okay. Article 2, Section 20, military power is subordinate to civil power. The military shall be strict subordination to the civil power.
Okay. So every state has a National Guard. That's what they're talking about here. They were not talking about that in 1912. Okay, they didn't have a National Guard then. They had a militia. All right. It's what it was called. But what they're talking about is the National Guard and or the militia is under the authority of the governor, which is civil power.
So civil power refers to the governor?
Well, it refers to the government. That's particular part is the governor can call up the National Guard. He's like the commander in chief of the National Guard. The same as the president is the commander in chief of all the military. Okay, which is so scary. Does that make sense?
Yeah, but was there something else constitutionally? Because I think I remembered reading it in Indiana. And I think I remembered it once being in discussion in one of the webinars. But is there another piece to this with regard to how the militia is not controlled? There's something about somebody being totally under control and they can't act unless, I forgot how it goes. But I thought there was another piece to this, Deborah.
Well, not in our Constitution.
Okay, I'll look in ours, but I kept thinking that there was something a little bit different.
Yeah,
That the governor had a certain power. Or maybe is it connected to the sheriff?
maybe.
Okay, I'll have to find what I'm
It's
thinking of.
possible because the sheriff's not considered military,
No,
so they just were wanting to make sure in all the states that there would not be a military coup going on.
but does that mean that the governor can, like with our situation now, send out the militia or send out
The National
the
Guard.
National Guard to attack the people?
No, he would have to have something like our border. I mean, Arizona's border. The National Guard could be called out to go protect the border, but it's not been. Abbott could call out the National Guard in Texas or whoever's in New Mexico. Those guys could call out the National Guard to help protect the border. They haven't done it.
And they could have protected the border that way.
Yes.
And Ducey could have for Arizona too, right?
Oh, yeah. Yeah.
I don't get that.
Okay. So,
I'll look and find what I was thinking of on, and I'll bring it back.
okay. So read section 21 now, Sandy.
Okay, Article 2, Section 21, free and equal elections. All elections shall be free and equal, and no power civil or military shall at any time interfere to prevent a free exercise of the right of suffrage. That's
Okay. How are we doing with that?
Yeah, really.
That's a problem across the whole entire United States, isn't it? And there's something like this, worded somewhatly different, but like it in every constitution,
Mhm.
all 50 of them. Okay, so
Mhm.
all 50 state constitutions have been violated. Because they have not had free and equal elections.
Mhm.
And they've absolutely been interfered with,
Mhm.
right?
Mhm.
Okay, so let's go on to the next page then, the next slide. And this is where it gets interesting here. So now,
Mhm.
bailable offenses, you wouldn't think that would be too interesting, but it actually is. And so,
Yeah.
so if you go back and remember for a minute, our Constitution allows for both initiatives and referendums, which, and some states it's only one, some states it's only the other. Some states don't have it at all. In a referendum, the legislature puts this question before the people on a ballot and as a proposition here in Arizona, and then the people vote yes or no on it. Okay. In an initiative, the people themselves initiate the question as a proposition, and they vote on it, and it, and it either passes or it doesn't. This particular section has caused a great deal of problems, apparently. So, Rima, please read this slide. You are muted.
She's muted. Yeah.
I
There we
didn't
go.
say be audible. I was reading.
Thank you.
Anytime. A, all persons charged with crimes shall be bailable by sufficient sureties, except 1, for capital offenses, sexual assault, sexual conduct with a minor under 15 years of age, or molestation of a child under 15 years of age when proof is evident or the presumption is great. 2, for felony offenses committed when the person is charged with is already admitted to bail on a separate felony charge. No, that would never happen. Where the proof is evident or the presumption great as to the present charge. So you can't double dip on bail. But I have a question about paragraph A1. Does that mean that the age of sexual maturity or consent in Arizona is 15?
I don't think so. I don't know why that's that way. I don't know. Okay, but let's keep going because things were changed here. So we're reading the Constitution, and then we're going to read about propositions. Okay, so go ahead and change the screen, Rosemary.
Okay.
And Sandy, you want to read this screen?
For felony offenses, is that what you're talking about?
Yes, please.
Okay. 3, for felony offenses, if the person charged possesses a substantial danger to any other person or community, if no conditions of release which may be imposed will reasonably assure the safety of the other person or the community, and if the proof is evident or the presumption great as to the present charge.
Keep going.
Okay. For serious felony offenses, as prescribed by the legislature, if a person charged has entered or remained in the United States illegally, and if the proof is evident or the presumption great as the present charge.
Keep going.
B, the purpose of bail and any conditions of release that are set by a judicial officer include: 1, assuring appearance of the accused; 2, protecting against the intimidation of witness; and 3, protecting the safety of the victim, any other person, or the community.
Okay, so this is all laid out and it's pretty clear, right? So any questions about what we see here? I mean, other than Rima has raised a very legitimate question, why 15? I don't know the answer to that.
Because is it normally 18, under 18?
Well, yeah, you'd think. And so, but any other questions about what you see here so far? Rima, go ahead.
I find this very, very perplexing because it says several times, if the presumption is great as to the present charge, if the proof is evident, or the presumption is great. But legally, we have a presumption which has to override pretty much everything, that you are innocent until proven otherwise. Therefore, you're being apprehended and held on the presumption that you're not innocent in a system where you are innocent until you're not. So I don't understand this at all.
Well, it's interesting, isn't it?
Mm-hmm.
It's very interesting. And of course, if we weren't studying the Constitution, we would never have read it,
Mm-hmm.
right?
Mm-hmm.
Okay, so we're going to go on for the moment and we can always come back. So go on to the next slide. Because there were 2 propositions and 2 amendments to this particular section of the Constitution in Arizona. So this one, what the first one was Proposition 103. It was ratified on November 5th, 2002. The Arizona judges allowed to decline bail for certain criminal, crimes. Hold on, let me get back here because I'm not reading it right. The Arizona judges allowed to decline bail for certain crimes amendment, also known as Proposition 13, was on the ballot in Arizona as a legislative referred constitutional amendment. So the legislature, it was a referendum on November 5th, 2002. The measure was approved. The Arizona Supreme Court overturned part of the amendment on February 9th, 2017. Okay. The proposition was designed to prevent courts from granting bail for certain crimes, including sexual assault, sexual conduct with a minor under 15 years of age, or molestation of a child under 15 years of age. Now, you have to know that when an amendment goes into effect, the wording of that amendment actually goes into the Constitution. Okay, so we saw this wording in the Constitution, didn't we? Okay. All right, so here's what happened. So go on to the next page. The next slide, rather. Okay, so Rima, you want to read Arizona v. Goodman?
On June 14th, 2016, the Arizona Court of Appeals overturned a section of Proposition 103 that denied bail to persons charged with sexual conduct with a minor under age 15. According to the Court of Appeals, bail could be denied, but not without determining whether the suspect posed a risk to victims or society. The court's ruling did not affect the measures section that denied bail to defendants charged with sexual assault or molestation of a child under 15. Maricopa County Attorney Bill Montgomery appealed the ruling to the Arizona Supreme Court. On February 9th, 2017, the Arizona Supreme Court, in a 4-3 divided opinion, ruled that denying bail to defendants charged with sexual conduct with a minor under age 15 violated the due process clause of the 14th Amendment of the United States Constitution. But I thought the states were superior to the U.S. Constitution.
Well, but their ruling on the basis of the federal constitution, aren't they?
Uh-huh.
Okay, so let's go on to the next slide.
So Deborah, you mean they're using the US Constitution to help them, right?
Right.
Okay, okay.
Yes. Okay, so now, Sandy, do you want to read?
Yes.
Okay,
Is that Uchner, Eckner?
something, we'll go with that.
Okay, okay. Euchre.
Whatever.
Euchner. Okay, like you play cards, right?
Yeah.
David Euchner as Assistant Public Defender of Pima County agreed with the court saying, the ruling, properly recognizes that a person charged with a crime, even a serious crime, is presumed innocent. Those
Rima! Keep going.
Okay, those accused of crimes deserve to be treated. Okay, sorry, my brain is stopping me while I'm thinking.
That's okay.
I'm processing while I'm reading. I need
I
to
know.
stop that. Okay, those accused of crimes deserve to be treated as innocent people right up until the jury returns a guilty verdict. Bill Montgomery, an attorney in Maricopa County, stated, while the court's analysis of the role of the supremacy clause properly gives no more weight to a citizen's initiative than any legislative act, and is certainly thorough and reasoned, it does not fully acknowledge the serial nature and therefore risk to the community that sexual offenses against children categorically present. Huh?
Okay, so what he's saying here is while the person is to be presumed innocent
Mhm,
and until declared guilty,
mhm.
there are situations where a person has serially assaulted and sexually abused minors. Okay.
Mhm.
And so in a particular case, the weighing of you're innocent until you're proven guilty needs to be weighed against the danger to the community of the sexual offenses against children. All right.
Mhm.
Okay. So now keep going.
Okay. Attorney General Mark Brnovich asked the United States Supreme Court to review the decision of the Arizona Supreme Court. On January 14, 2019, the US Supreme Court denied the request without comment.
Okay. So they refuse to hear it. All right. So now that's one of the things that was added in there. And just remember that when an amendment passes and becomes law, the language of that amendment, if it's a constitutional amendment, that language then gets put into the Constitution.
Does it replace anything? Or is it just added? Or it depends on what you're,
It depends.
okay, okay.
Okay.
That's like the grand jury amendments that we see that we have to go back.
Yeah.
Okay. But
Okay.
those rulings still stand, right?
Yeah.
Okay.
All right. So go on to the next slide. So now we have, let's see. We have another one, and I didn't highlight everything again because so anyway, this is called Proposition 100. And this was in November 2006. The language that appeared on the ballot is what we have here. So Rima, you want to read that one?
The Arizona Constitution provides that all persons who are charged with a crime are eligible for bail subject to certain exceptions. Bail is not allowed for any person who is charged with a crime if the court finds proof that the person committed the crime is evident, or the presumption that the person committed the crime is great, and the charged crime is one of the following: a capital offense, an offense punishable by death, sexual assault, sexual conduct with a minor under 15 years of age, or molestation of a child under 15 years of age, which would be sexual conduct with a minor. So I don't understand the
I know.
redundancy. Never
I
mind.
know.
2, nobody asked me. 2, a felony offense committed when the person charged is already admitted to bail on a separate felony charge. 3, a felony offense if the person charged poses a substantial danger to any other person or the community, and no condition of release will reasonably assure the safety of the other person or community.
Okay, so that's what was in the proposition. All right, so go ahead to the next slide. Impact. So Proposition 100 would amend the Arizona Constitution to additionally prohibit bail for any person who is charged with a serious felony offense as determined by the legislature if the person charged entered or remained in the United States illegally, and the court finds proof that the person committed the crime is evident, or the presumption of that person committed the crime is great. In 2006, the legislature enacted legislation to specify that, and this is not in here, I'm reading this because I forgot to put it in, I'm so sorry, but you have it in your notes. To specify that class 1, 2, and 3, and 4 felony offenses would constitute the serious felony offenses for which a person who has entered or remained in the United States illegally shall be denied bail. The legislation does not become effective unless Proposition 100 is enacted. So that was part of it that I didn't put in there. Who knows why? All right, so Rima, can you read the impact?
The bill would have prevented bail for those charged with a serious felony offense and that could not prove that they were in the U.S. legally. Arizona Proposition 100, also called the Bailable Offenses Act, was on the November 2006 probably ballot in Arizona as a legislatively referred constitutional amendment, and it was approved. Chief Judge Alex Kozinski announced in January 2014 that the Ninth U.S. Circuit Court of Appeals decided to review this law in March of 2014.
Okay, and we do know, if we're paying attention to anything, that the Ninth Circuit Court of Appeals is the most liberal of all the circuit courts of appeal in the United States. However, so it says both of these amendments were legislatively referred constitutional amendments. And so I don't have any more information about that Ninth Circuit Court of Appeals review of this, except that I think that if it had overturned it, it would have been in the information. So I think they left it alone.
I have an 8 o'clock standing appointment. So are we going to be starting at 7 from now on instead of
No.
6:30?
Not necessarily. Rosemary just had a late appointment today.
Okay. So I would love to stay because this is really, really interesting, but I have to go.
Okay. Bye.
Hi, Rima. Nice to see you.
Hi, Jody.
Bye.
Okay.
I don't see her.
She's got her affidavit mama thing up there.
Oh, I see. Okay,
There she is.
Oh, okay.
Okay, so anything that we want to discuss about this, about the bailable offenses, about the referendums, about the legal stuff that's all flowing around about this, anything that we want to discuss about this?
The only thing I could think of, Deborah, is there's so much of this being violated right now
Yep.
with all the child trafficking.
Yeah. And Rima's question about why 15 years old is absolutely legitimate. And I don't know the answer.
I wonder if they did it because they knew Well, why would you do it? What's the advantage of 15 versus 18?
I don't know. I'm gonna have to dig into it some because it's a legitimate question.
Okay, and then I have another question. It's just the piece that's in here. I guess, probably it's because I'm weak in understanding. Like when you said the Ninth US Circuit Court is the most liberal. It's like, I do not know that much about the courts, because when you talk about, sometimes we talk about something happens in a court, like some of the mandates that were turned around in certain courts. I don't quite understand that structure. That's like a whole new different piece of study, isn't it?
Well, so if you recall back in the US Constitution, the US Constitution, in the Constitution created the Supreme Court.
Okay,
It also told the legislature in their section of the US Constitution that they were to create lower courts.
okay,
Okay. And they could do that with legislation.
okay.
All
So let me see where you're going. So you have the United States Supreme Court that's over all the states. And what they wanted to do is they wanted in each state for them to create their own court system.
Well, and yes, and so in every single constitution, it's a state constitution, there is an article about their court system. But let me continue here with the US Constitution for a second. So
Okay.
so the United States legislature, the Congress, was to create lower courts than the Supreme Court, which they have done. And so one of the things that they did was directly underneath the Supreme Court, they created the United States Circuit Court of Appeals. Okay, which is what this one is, ninth. Okay, there's and I don't know how many there are. They're like territorial in that they cover various parts of the United States, and each one of them is assigned to a Supreme Court justice.
Okay, all right. I just didn't
Okay.
understand the structure of it. Now,
Right.
I've got an idea. Okay,
Okay.
yeah.
And then so then there are some other stuff below there, but then we need to go back to the states,
Right.
So the states in their constitutions have one or more. In Arizona, it's at least 2 articles on courts and judges, where they create the courts, starting with the Supreme Court. There's a state Supreme Court.
Mhm,
There's a state appeals court.
mhm,
There's a state superior court.
mhm.
And then there's the local justice courts,
Okay,
right?
okay. Mhm.
Okay,
Okay, that makes more sense to me now when you're talking about the higher courts.
right.
Okay,
Right.
thank you.
And the Ninth US Circuit Court covers our area of the United States and is located in California.
Okay,
So they're extremely liberal in their
Okay.
decisions.
okay. That's pretty interesting. That's a whole new different piece.
Yeah.
Okay,
Okay. So, and again, if we weren't studying the state constitution, we wouldn't be looking at any of this, and we wouldn't know that any of this had happened.
right.
And so with that in mind, we're going to go on to the next slide. And how are we doing time-wise? Oh, we're doing okay. All right. So what Rose and I discussed was we needed to show everybody how to write an affidavit if we, just to do it like we've
Mhm.
done with the notice. And so we decided that we would do it about DCS, which, what's it called in Indiana, Sandy?
Child Protective Services,
So
CPS.
CPS. Every state, well, a lot of the states have different words or order of words or whatever. But it all boils down to the same thing. They're taking children.
Mhm. Mhm.
So that's what Rose and I decided that we would write the affidavit about. Hopefully that's all right with everybody, because we just sort of made an executive decision about that.
That's fine. You're the teacher.
Well, and it's something that's universal. And I decided as I was starting to work on it that it needed to be universal across all of the states rather than unique to Arizona.
Mhm.
And so you'll see that I've done things quite differently than if it was just Arizona.
Mhm.
Okay, so Jody, you feel like reading, hun?
Oh,
She's-
okay.
You don't have to if you don't want to. It's fine. It's up to you, babe.
It's
Oops, she just,
oops. It's hard for me to read it. I'm sorry.
no, it's okay. It's all right.
Okay. I'm
right.
listening though.
Okay, that's fine. So, all right, so I'll read this first part. Comes now affiant is how we always start affidavits, okay? And then the person's name. So you're the affiant, whoever is going to have, it's going to be notarized, whoever's name is going to be on there, they're the affiant, okay? And so one of the people, as seen in the 50 state constitution, so right away, I've changed it. And what I'm saying is I'm going to use all 50 state constitutions, or I may use all 50 state constitutions if I so desire. Okay, because I'm an affiant in all 50 states, is what I'm
Okay.
saying.
Mhm.
Okay, sui juris in this court of record means that I'm standing on my own, and this is a court of record because when I get this notarized and it's stamped, it becomes its own court of record. All right.
Mhm.
Coming to you, the elected agents of the people to receive due care and relief from harmful, unlawful agencies and courts. And so I've stated in this first section why I'm writing it, why I'm sending it to you. Any questions about that?
Mhm.
Okay. So then it says affiant states that we, the people, have all political power and inalienable rights to life, liberty, safety, property, and happiness. Affiant, one of the people, states that all 50 state constitutions are not only interchangeable, but relevant to my needs as one of the people. So again, I'm stating I can use any constitution I want, and it's too bad if you don't like it. Okay.
Mhm.
All right. So let's go on to the next slide. Sorry. Oh, you're fine. Okay. All right. So, Sandy, you want to read on this page?
Sure. All right. Ohio Article 1, Section 1, inalienable rights. All men are by nature free and independent and have certain inalienable rights, among them which are those of enjoying and defending life, liberty, acquiring, possessing, and protecting property, and seeking and obtaining happiness and safety.
Okay. And David has taught me that we put at the end when we highlight, emphasis added by highlight.
Okay, does that need to be in bold?
No.
Okay, okay. All right, let's see, what's the next one? Okay. Affiant notes that one of the people who hold all political power, I may alter, reform, or abolish all governmental agencies that wish to violate inalienable rights of the people. This is clearly stated in multiple state constitutions. Example in point. Ohio Constitution, Article 1, Section 2. All political power is inherent in the people. Government is instituted for their equal protection and benefit, and they have the right to alter, reform, or abolish the same whenever they may deem it necessary, and no special privileges or immunity shall ever be granted and may not be altered, revoked, or repealed by the General Assembly. Wow, I like that one. That's pretty good.
So, so somebody in one of the Telegram chats was suggesting using some of the Ohio Constitution.
Mhm.
I had looked at it for other purposes, for someone, for a notice, but I hadn't really looked at it for these purposes. And but they were right. It's well stated. And so do you see how we set it up and then we put the Constitution in?
Mhm.
Okay, now this is not in stone by any means at this point. This is just what I came up with over the last day or so. And it can absolutely be changed at any point. Any other comments about this? Okay, then let's go on to the next slide.
In the middle of this here. Is that the right one, or did it go too far?
It went too far, I think, Rose.
Okay.
There
was
we
that-
go.
Okay.
Okay, thank you.
Mhm.
Massachusetts Constitution. So what I decided was, okay, we're just going to go around the United States.
Okay.
All right.
Mhm.
So Massachusetts Constitution, the first, Article 7. Government is instituted for the common good, for the protection, safety, prosperity, and happiness of the people, and not for the profit, honor, or private interest of any one man, family, or class of men. Therefore, the people alone have the incontestable, inalienable, indefeasible right to institute government, to reform, alter, and totally change the same when their protection, safety, prosperity, happiness require it. Okay, Josh likes this particular one a lot. He's used that one. All right, so then we go to Kentucky.
I have a quick question.
Yes.
Hold on. Because Jill and I were talking about this just last night for her slides. Is there a difference between unalienable and inalienable? Because we've seen it differently.
Yes.
Oh, they mean two different. Unalienable would mean not.
Exactly.
Inalienable
Not-
would mean within, right?
Yes. Let me just see. I'm looking it up right now. Hold on. I don't think there's such a word as unalienable.
Like as it's written, right? In Massachusetts.
Oh, yeah.
Because I've seen, because
I would have to look it up.
Yeah, see, because look at Kentucky has inalienable.
So I wonder if it's just a spelling error.
No, some of the constitutions do have because I've seen it.
I'm gonna have to look it up.
Okay,
All right, let me just mark that so I can look it up.
well, maybe I can do that on this next reading.
Okay. So Kentucky, all power is inherent in the people and all free government is founded on their authority and instituted for their peace, safety, happiness, and protection of property. For the advancement of these ends, they have at all times an inalienable and indefeasible right to alter, reform, or abolish their government in such manner as they may deem proper. Okay, now
Mhm.
I put all these in here just to start with, and frequently I take some out after a while.
Okay,
Okay. I just put them all in there just so I have them in front of me. And then I went, okay, that's too much. Okay. So I'm just saying that's how I think about it.
mhm,
Okay.
mhm.
All right. So go on to the next slide.
I'm sorry.
That's okay, hon. All right. So Appian states that Kentucky also recognizes that no government or administrative court or agency may impinge on the private rights of one of the people. So read that Kentucky one, Sandy.
Sure. Kentucky Constitution Bill of Rights, Section 2. Absolute and arbitrary power over the lives, liberty, and property of free men exists nowhere in a republic, not even in the largest majority.
Okay. So then I say Appian states that courts of record are created in all state constitutions. The United States Constitution simply allows for the Supreme Court and creation of lesser courts by the legislature. Please notice that no state constitution or in the federal constitution is there any allowance made for administrative courts that function outside of the courts of record and without a trial by jury and inalienable right of the people. Okay. So now I'm setting up my case that they're violating all these constitutions with their administrative courts.
Okay, so when you, in this statement, you're basically saying that the tribunals, what are the other courts, hearing, and the administrative courts, they're basically not applicable.
They're
because
not
you have to-
lawful. They're
yeah,
not
you-
lawful.
Because they have to have the jury, right?
They have to
Okay.
be a court of record.
Okay. I'm just trying to make
Because-
sure I'm solid with understanding what you wrote.
Because, and we'll see it next time we do the Constitution, trial by jury is a constitutional right, right? Both
That's
with the both
due
with the state.
process.
Yeah, well, due process is a separate heading in the Constitution.
Mhm.
And that's right, you're right. But trial by jury is specified in all the state constitutions and the US Constitution.
Okay,
And we'll go over the trial by jury next time. I just wanted to get at least started on looking and thinking about this this time.
mhm. Oh,
Okay.
okay.
All right, we are coming up to the last slide here. And what I'm saying is search for maxims that will make the point. Look at other state constitutions for good or better wording. And I wanted to show you something here in this, because we come across these rulings all the time. And I don't think even David has spelled this out. It's something I just realized. So the rule of thumb is if you're going to use a Supreme Court ruling, you better go read it.
Mhm.
Okay. And so it says, read any Supreme Court case that you wish to quote from. Do not use quotes without reading the cases. And in one of the ones that Jennifer with this situation in Sarita had found for me, it's not this one that I'm using here. They had misquoted it in this book that she was getting it from. Okay, they had added some stuff to it that was not in the case.
Mhm.
And I thought, well, there you go. And besides that, having read the case, or at least skimmed it, now you have an understanding of why the quote works for what you want it to work for. Okay, which is why I'm using this one. Okay, so the rulings usually give this section and or page numbers where the quotes are found. And that's what happens here with this. So you see, it says Miller v. United States of America, U.S. Court of Appeals for the Fifth Circuit, and then it gives these numbers. Well, the last number before the parentheses is the page number where you're going to find the quote.
Oh,
So you can do a Google search by just putting in Miller v. United States of America, or you know that, you just put in that and it will show up. What I'm saying down below is it'll show up in various different ones in the Google search. Use the Justia Law search engine to read it, okay?
mhm.
And so the 486 is the page number that you're going to find this quote on. All right.
Mhm.
Well, in this particular one, it was quite interesting. They had said that this woman was committing a crime because she was standing on her constitutional rights. Here's what happened. The police showed up at her door and said that they wanted to come in to her house, and they wanted to arrest the man who was the boarder at her house. Well, she wouldn't let him in because they didn't have a warrant.
Mhm.
And so then they had to leave and go get a warrant and then come back. So they arrested her for obstruction of justice. Well, the Court of Appeals, this is the Fifth Circuit Court of Appeals, by the way, Sandy, you'll see.
Mhm.
This one is in Alabama, I think.
Okay.
They say that the execution of process and the performance of duty by constituted officers must not be thwarted, so the police shouldn't be thwarted, but these agents, servants of a government, isn't that interesting? They're servants of a government and a society whose existence and strength comes from these constitutional safeguards, are serving law when they respect, not override, these guarantees. The claim and exercise of a constitutional right, no, you can't come into my house without a warrant, cannot thus be converted into a crime.
Uh-huh.
Okay.
Mhm.
And so, and you can find this in the Justia Law, in this case, on page 486.
Why do you choose Justia Law?
Just because it gives you the complete case.
Okay.
David uses that one all the time.
Okay.
And it gives you the whole case, not just a summary, I wanted to find where it said this.
Okay.
And so now that we know the situation of this woman, and it makes it more interesting and more relevant to things that we might use this for, right?
Mhm.
Because you know the situation that the woman was in that caused her to be in this Fifth Circuit Court of Appeals. You know, she was arrested for doing what was right. The
Yeah,
police,
she knew her constitutional right.
right, right. So anyway, what I'd like for everybody to do is to just sort of start thinking about other constitutional references, what should come next, maxims. It's probably too much constitution at the beginning of this right now. And we probably don't need to use 3 different references to constitution for abolishing and reforming. We probably don't need to do that. But I frequently do that to start with, just so I can pick and choose which one I want to use in the end. So any other comments or thoughts or anything?
So really, in order to go to advance and look for more material to work through this affidavit, we have to think, what's the next point of discussion, right?
Right. It does not have to be, 5 pages long or anything, which is my point in taking out some of the constitution that I put in. What I've found is, and I think David's been showing me that lately, is that it's better to be using some of the maxims than it is to be using even the Constitution, because they're more, this is a word I've been using lately, they're more knife-like.
Yes.
They're more, they cut more, right? So next time, we will be looking at the trial by jury, both in the Arizona Constitution and in the US Constitution.
Okay.
We'll be looking at that. So did you stop the recording, Rose?
Going to